Morning to all. I am M.MUTHUSELVI, Assistant Professor, Department of Commerce with Computer Applications, Dr. DRSNSRCAS, College of Arts and Science, Coimbatore. Now I am going to discuss about the topic of contract. A contract refers to the termination of the contractual relationship between the parties involved. A contract can be discharged in several ways, and the method of discharge depends on the circumstances and the terms of the contract. Next one is performance. A contract is typically discharged when both the parties fulfill their respective obligations as specified in the agreement. This is known as performance. Once a performance is completed, the parties are generally relieved on their contractual duties. Next one is agreement. The parties may mutually agree to discharge the contract. This can happen through a uh, noti- notification, which is a new agreement that replaces the original contract, on by a simple agreement to end the contractual relationship. Next one is breach of contract. If one party fails to perform its obligation under the contract, it may lead to a breach. The, the, the party may choose to discharge the contract due to the breach, and may be the legal remedies for the damages. What is meant by breach of contract? Breach of contract, that is a specific concept of relating to the contract. Types of breach of contract. First one is contract can be categorized into various types based on their natural and purposes. Common types of breach of contract is: first one is express and implied contract. Second one, um, neutral and bilateral contracts. Third one, executed and executory contract. Then valid, void, and voidable contract. These are the four types of contract mainly followed in the breach of contract. First one is express and implied contract. Express contracts are explicitly stated, while implied contract are inferred from the parties' conduct. Then unilateral and bilateral contract. In the unilateral contract, one party makes a promise in exchange for the other party's performance, while a bi- bilateral contract involves promises from both the parties. Then executed and executory contract. The executed contract is one in which both the parties have fulfilled their obligations, while an executory contract involves duties yet to be performed. Then valid, void, and voidable contract. A valid contract meets all the legal requirements. A void contract is not legally binding, and a voidable contract is valid but can be void by one of the parties. Bec- Breach of contract occurs one party fails to perform its obligation under a contract without a legal excuse. There are various types of breaches, that is, material breaches, uh, anti anticipatory breaches, then minor or partial breach. First one is material breach, a significant failure to perform that goes to the core of the contract. Second one is anticipatory breach, a situation where one party indicates before the performance is due. Third one is minor or partial uh, breaches, the less significant failure to perform. These are the main types of breach of contract. Then common remedies for breach of contract is damages, specific performance, injunctions, and re- resi- resistance. These are the common remedies to avoid the breach of contract. Thank you.